On January 12, 2022, a 5-judge constitution bench reserved judgment in a dispute that is very familiar to the court, the Bhopal Gas Tragedy. In 2010, a curative petition was filed by the Union government to increase compensation for the victims. Ever since 42 tons of highly toxic methyl isocyanide leaked from a pesticide plant owned by Union Carbide Corporation or UCC in 1984, the sheer scale of the damage and the loss of life brought the amount of compensation owed to the victims into stark focus. In 1989, the Supreme Court facilitated a settlement between the Union and UCC for $470 million. However, even at that time, many believed that this settlement amount was insufficient. Prompted by widespread protests, the Supreme Court agreed to review the settlement. In 1991, the court refused to increase the settlement amount. With few options remaining, the Union filed a curative petition. Curative petitions are relatively new judicial innovations. The Supreme Court introduced this avenue for justice in 2002 to allow the court to provide relief when one of their own past orders resulted in a gross miscarriage of justice, meant as a last resort. Curative petitions greatly restrict the situations where the Supreme Court can provide relief. A 5-judge constitution bench led by Justice Sanjay Kishan Kaul heard the case over 3 days in January 2022. The Union and other civil society organizations claimed that new facts had emerged since the 1989 tragedy and the damage caused was far greater than what was originally assumed. Attorney General R. Venkataramani, representing the Union, argued that the immense amount of human suffering justified the court's intervention through a curative petition. Further, the Attorney General was clear that the Union did not want the bench to reconsider the 1989 settlement. It only wanted the court to direct UCC to pay additional compensation. Throughout the hearings, the bench repeatedly voiced their hesitation at expanding the scope of a curative petition in order to increase the compensation amount. In the words of Justice Kaul, they were concerned about opening a Pandora's box by increasing the settlement without reopening the original settlement proceedings. They also pointed out that the victims who had filed claims had received their compensation, but the Union had taken exorbitant amount of time to give the victims their compensation. Further, due to shifting exchange rates, nearly half of the initial settlement amount still remained after addressing all the claims. This leftover amount was handed to the victims once again, and there was still currently 50 crore rupees remaining from the settlement. Senior advocate Harish Salve, representing UCC, argued that the Union has changed its stance since the 1989 settlement. In 1991, they were in favor of reopening the settlement proceedings, and between 1995 and 2011, they had submitted affidavits to the Supreme Court opposing every claim that the settlement was inadequate. Will the Supreme Court expand the scope of curative petitions to provide relief in cases where there is an overwhelming social interest? Stay tuned to the SE Observer website to find out.